Hi, good afternoon. Hi. Welcome to the Robert Zicklin Center for Corporate Integrity. I'm David Rosenberg, director of the center and a professor in the law department here at Baruch College in the Zicklin School of Business. I'm very excited about the really excellent program that my colleague Marc Edelman has put together on college athletes as employees, which I think will have obvious relevance to our mission to talk about ethics and integrity in business and in organizations in which large sums of money are earned and dispersed. And so I think it has really obvious relevance to the kind of subjects that we like to talk about here. We have a really distinguished panel with three panelists, which Marc will moderate. They'll each speak a little bit to begin with and have an exchange of views, and we'll have plenty of time for questions at the end. How are we doing the questions today? We have a microphone. We'll bring out microphones and we'll put them on each side, and you'll just stand up and pose your question. Please, no speeches. Please, short, direct questions. So let me introduce my colleague Marc Edelman, a professor of law here at Baruch College.
Good afternoon, everybody. Afternoon. Well, first, welcome back to the Zicklin Center. It's a pleasure to be back now with live events, and thank you for coming down today. For those of you who followed the past sports business and ethics panels that we've had, this is not the first time we've talked about the topic of college athletes' rights, but we're now moving into the third different area within college athletes' rights. A few years ago, we spoke about name, image, and likeness, and the idea of allowing college athletes to endorse products for money. And we had online the first ever, other than myself as moderator, all-female panel, and we discussed the opportunity for women's college athletes to endorse products for money, featuring Nancy Skinner, the state senator of California. And on other panels, we've talked about sports and antitrust law and the possibility of challenging some of the restraints on college athletes through using antitrust law and promoting free markets. Today, we're turning to talk about a third area and a third topic as related to college athletes' rights. We're going to hit the very provocative question of, are college athletes employees? And maybe implicitly, should college athletes be able to unionize? I'm incredibly grateful that we have three wonderful panelists here who are joining us today. On our far left, we have Michael Tsu, who's joining us. Michael is a tech entrepreneur who worked in consulting. He had served as a trustee for the University of Minnesota. You can see the colors on his tie. And on the groundwork, Michael has been actively involved in working with the National Labor Relations Board to try to have at least certain college athletes classified as employees. Immediately next to Michael, we have Professor Jeremi Duru, who's currently on faculty at American University Law School in Washington, D.C. Jeremi is really the perfect panelist for us to have here today because he teaches not only sports law, but also teaches employment discrimination, directly on point to this topic. And in addition to his sports and employment discrimination work, Jeremi has published on equal rights and topics of racial justice, which perhaps will come into this conversation as well. And immediately next to me is John Holden, who we've had at this center once before, at least in the online format. John is a faculty member at Oklahoma State University's Spears School of Business, where he teaches sports law as well as gaming law. I've had the pleasure of writing extensively with John Holden on a number of sports law topics. And John and I, along with Professor Michael McCann, have just completed a paper on the college athlete employee. So John will talk about aspects with respect to our paper, and we'll also try to tackle the question of when, if at all, should a college athlete be treated as an employee? So Jeremi, let me start with you. And before we get to the present day, there are probably some people in the room that hear college sports and think of this as being purely recreation. Now, as an interesting fact for you, Jeremi, before you get into your background, here at Baruch College, our #1 revenue source from college sports, it comes from leasing our gym to outside parties. Now, that might not be the full picture everywhere in the country. So going back as far as you'd like to go, how did we even get to the point where this was an issue?
Sure. Well, first of all, thank you, Mark, for having me here. It's a real pleasure to be here at this august panel and to speak with you about this really important topic. And definitely, at some point, I'd like for us to talk about race and civil rights, because I don't think there's a real way to discuss this issue. We'll talk about some of the context as to why, but without discussing race and civil rights. The reason we're all here talking about this is because collegiate athletics is huge business in this country. Huge, huge business. But let's go back to when it wasn't huge, but just so we can contextualize where we are. So collegiate athletics, I think it was a regatta with Harvard and Yale in a boat race. But the first game that involved a sport that's now revenue producing was a game that involved Rutgers, football game, Princeton and Rutgers in New Brunswick. At that game, there were 100 spectators or so, none of whom paid to get in. In fact, there was no getting in. There was no stadium. It was just on a field. The students were truly students who engaged this athletic enterprise against the other school. There were not even coaches as a part of the game. I think Rutgers won 6-4 or whatever, and then the sport of football moved on from there. But where did it move on? Well, let's look now. So Rutgers plays in a stadium in New Brunswick, not on that field, in the stadium, that can hold 52,000 people. Everyone who comes in is paying. Now there are coaches, and the head coach of Rutgers football team gets about $3.5 million a year. The football team is part of a larger athletic department with a bunch of other sports teams. The head of the athletic department, athletic director, gets about $1.7 million a year. The University of Rutgers, with that athletic department, is a part of a conference called the Big Ten, where you have a bunch of other schools in the, I think 16 now, am I right about that? 18. The head of the Big Ten conference, the commissioner, gets, I think, $4 or $5 million a year. The Big Ten is a part of the NCAA, something you've probably heard of, National Collegiate Athletic Association, a nationwide entity, member institutions. Most of the universities in this country are member institutions. The head of the NCAA gets, Marc Edelman, when he left the president, he got about $3.5 million. I think the current president, Charlie Baker's more than that. Okay. And the student athletes still aren't getting paid. So you have this context initially where it truly was an amateur enterprise. Nobody got paid. Everyone was on the field just playing and observing. And now everybody's getting paid. There's huge amounts of money, television revenue in the billions of dollars, and the student athletes still aren't getting paid. And so that begets the question, should we view them as individuals who should get paid or must get paid? Should we view them as employees? That's how we got here, I think, Mark.
Thank you, Jeremi. And just one stat to throw onto that, the highest revenue-generating college sports program right now, The Ohio State University, brings in $252 million with an M dollars per year from college sports. Most of that was from football. Comparison, another sports program based in Columbus, Ohio, the NHL Columbus Blue Jackets, professional hockey, bring in more than $100 million less per year than Ohio State University. John, let me turn to you for a few minutes here. Jeremi gave us a really wonderful overview, quick overview, incredibly appreciated, of the history of college sports from how we got where we were from Elisha Fields in the 1840s to where we are today. John, before we get to the college sports context, what's an employee? Who's an employee, just generally?
So generally, when you think of who is an employee, a lot of people think, if you go to work, you do a job for someone, you're an employee. It's a lot more complicated than that. And at the federal level, we have the National Labor Relations Act, which sets out guidelines for who's an employee. And it largely depends around the employer, the institution's ability to control what you do at work. We also have the Fair Labor Standards Act, which was a New Deal piece of legislation, which similarly centers around how much influence an institution has over what you do during the day. So when we're looking at the college athlete context, look at a college athlete. What are their responsibilities during the day? Well, we certainly know they go to class, right? That's a fundamental piece of college athletics, is that they are still students. But a growing piece of what they do are their responsibilities to the athletic department. So the time they spend practicing, the time they spend in the film room, all these other things. And when you start looking at some of the pieces that these federal laws lay out for what makes an employee, the ability to control the time of the employee, the ability to hire and fire, these types of things, you start ticking a lot of boxes over the amount of control that the institution has over these athletes at their school, and that piece that has been hung on to for many years, that student piece, really gets smaller and smaller when you start looking at the modern sort of college athletic environment.
Thank you. Now, Michael, we'll get to what you are doing in a little bit, but I'd like to ask you about some of what was done before you directly got involved. And when we talked last night, you seem to have a very real, good understanding of the history. So even though we're talking about the idea of unionizing college athletes or treating college athletes as employees, even though it sounds incredibly novel, the reality is the seeds for this go back at least as far as 2015. And the work you're doing now is really the outgrowth of what went on with Kane Coulter and Rigomi Yuma at Northwestern University right around the 2015 period. So Michael, we'll come back to you for your actual work later, but could you just tell us a little bit about these seeds and the Northwestern efforts to unionize and what happened 8 years ago that set the stage for where we are today?
Well, thank you, Mark, for that, and thanks for having me here today. The whole thing started in about 2014. Kane Coulter, who was the quarterback at Northwestern, apparently was taking a labor law class and took a trip over to Gary, Indiana, and saw kind of what was going on at the steel mills there. And I think his mind started turning, and he said, hey, wait a second, I'm a worker. Later on, convinced his teammates to file for unionization with the NLRB, which in turn was approved. They were determined to be employees. That's the interesting thing about college athletes. If you talk about a Starbucks unionization, they start as employees. But at Northwestern, they had to make a determination of whether or not they were employees. And the regional director in the Chicago region decided yes, they were. And it very famously then was appealed to the board in Washington. And the board decided not to take jurisdiction of the case, and it basically ended at that point. And I don't know if that's kind of the gist of what you're looking for. Or...
That's wonderful. Now, that's really, really helpful as context of 2015. Now, I'd like to do now something that I don't know if any of these panels have done before they've talked about Northwestern, because we've always talked about Northwestern exactly in that light. And the story you shared, Michael, is exactly the public version of the story that we know. Why did Northwestern make an effort to unionize in 2014, 2015? Well, Kane Coulter, their star quarterback, was taking a labor law class. Now, one of the questions I'd always wondered from that point in time was it just that the star quarterback was taking a labor law class, or might there have been more going on at Northwestern than we publicly knew? And interestingly for us, Sadly for us, over the past several months, a lot more came out about what was going on with that Northwestern University football team around that period of time, 2014, 2015, when they unionized. Now, I don't know if we can necessarily put this together as cause-effect, but we certainly could talk about what was going on with that team at the point they took the dramatic step to unionize. So, Jeremy, I think this plays right to you. What have we learned over the past few months was the culture at Northwestern University at the point in time when Kane Coulter was working with Magomi Yuma to try to form a union?
Yeah, it's a great point, Mark. It's a great point. Often we look back on history and we see things in a certain light, and then we later learn new facts, and it forces us to view things in a different light. So what's come out recently is that Northwestern University was a horrific place to be a football student athlete at the time. Baseball as well, by the way. It wasn't just football, and perhaps other sports. But the football program was, the culture was horrific. There was substantial hazing of student athletes by more senior student athletes. Apparently, they themselves were hazed before them, and then before, but something went on for a long time there. There's an allegation that coaches knew about it and didn't pay attention. The head coach was fired. The head coach is now being sued. In addition to physical hazing and sexual-related hazing, there was racist hazing. It was just a horrific dynamic. And so Mark's absolutely right. Do we know whether that impacted Kane? I don't know if any of us can say yes, but it certainly could have. And I think the bigger point is, while what I just described happening in Northwestern, I think is probably a little anomalous. I don't think all major football programs in college have that sort of dynamic. Hazing is certainly not something that we don't see in other places. It's also the case that there's, going to the point that was made about what defines an employee, there's an incredible amount of control over the comings and goings of student athletes, so much so that some might consider that in itself to be a haze. And so the dynamics at Northwestern were probably ripe for Kane to do what he did. But I would say, Mark, that at any number of Power 5 universities in this country, there are dynamics that might make a student athlete think, hold on a second, I'm really not in control of what I'm doing here. A lot of people are making money. I'm not making any. Perhaps there's a legal remedy.
Jeremy, if I could follow up with you for one more. When I spoke at the College Athlete Rights and Empowerment Conference at Drexel University in 2016, and I spoke there alongside Kane Coulter and Magomi Yuma, Dr. Harry Edwards from University of California was there. Just by show of hands, how many of you have heard the name Dr. Harry Edwards before? Dr. Harry Edwards, amongst other things, was, if you guys remember, in the 1968 Olympics, when you had the 3 athletes who stood up and took a stand against racial oppression in the United States and other places, Dr. Harry Edwards was directly involved in organizing that. Professor at the University of California and is seen as one of our civil rights leaders of this era. He said something that I think has to stand out to people. Dr. Harry Edwards, with all he's done in the civil rights movement, said that the college athletes' rights movement is the civil rights movement, and then he clarified as the civil rights movement in sports of this era. What do you take of that statement?
It's a powerful statement. I think there were 5 people in the audience who raised their hands saying they knew who Harry Edwards is. It's even more powerful if you know more about Harry Edwards. I would encourage everybody after this panel to spend 5 minutes just Googling Harry Edwards and learn about what he's, it's happening already, about what he's done. He's truly an extraordinary individual. Incidentally, it goes beyond the scope of this panel, and people have different perspectives on it. But he also was very influential with Colin Kaepernick, with respect to Colin Kaepernick's knee that he took in opposition to racial disparities in the criminal justice system in this country. Anyway, so to your question, Mark, so what makes it a civil rights issue is this. So far we've talked about, I mentioned the baseball, but otherwise we've talked about football. I mentioned when I first talked about the Rutgers-Princeton game, revenue-producing sports. In this country, the sport that produces the most revenue in college athletics is football. There's really no argument about it. Then you have basketball, men's basketball, women's basketball. In some places, I think Minnesota, maybe hockey brings in some money, and Iowa wrestling. But generally, it's football and it's basketball. And when we look at football and basketball, we see that the rosters of collegiate athletic programs are disproportionately of color, disproportionately African American. And so what Harry Edwards is getting at is that in this battle for student athletes to get paid, be viewed as employees, student athlete rights, we're talking about student athletes getting a share of the enormous revenue that comes in from collegiate athletics. That comes in principally from basketball and football, and that is played principally by people of color. So when we're talking about student athletes who aren't benefiting from a piece of that pie, we're talking principally about student athletes of color who, it could be argued, and Harry Edwards would argue, are being exploited at their expense for the benefit of these institutions. And so that's why Harry Edwards says this really is a civil rights issue.
Now, there's been real momentum, even if 2015, when it seemed to be a very narrowly looked at issue, well, the Northwestern football players should be treated as employees and allowed to unionize. It seems that over the past few years, there's been a lot more movement in various different ways to change the classification of at least certain college athletes. And one of the movements that's ongoing is Paul McDonald, who is a lawyer based in Pennsylvania, is involved in a case that's trying to get a court to recognize at least certain college athletes are employees. John, could you talk a little bit about, just on the high level, the Johnson case and what's going on in the Third Circuit?
Sure. So over the last decade or so, we've seen a number of college athletes and advocates raise issues of college athletes' rights as employees or workers on a campus. And we talked about the Kane Coulter and the NLRB route at Northwestern, and I'm sure we'll talk about the USC players, but that's through the NLRB route. There's also another route which I mentioned, which is the Fair Labor Standards Act route. And these are two federal laws that cover slightly different things and come with different rights associated with them. So the Johnson case involves a group of athletes who were at private universities. Johnson was a football player at Villanova, I believe, and so they filed this case, and a lot of people expected the district court to just grant the motion for summary judgment, and this case would go away. That didn't happen. And what ended up happening was that the judge denied the motion for summary judgment and looked at the case and effectively said that the plaintiffs in this case are raising enough issues that we can't dismiss it. And we have to move forward. So that decision is on interlocutory appeal at the Third Circuit right now, which hopefully doesn't come down during this panel, because then we'll have to throw out this whole video. But effectively, the Johnson players are raising the issue that the schools are ticking all the boxes in the Fair Labor Standards Act to control the economic realities of controlling the players. So they have the right to hire and fire the players, they set the work rules, the compensation that they receive, they're involved in the day-to-day business of what the players do. They control where they eat. They control where they sleep. All these things, that degree of control that the schools are exerting over the athletes is, I mean, in reality, it's probably greater than any of the staff or faculty on those campuses, but it is enough that under the Fair Labor Standards Act, they should be considered employees. And if they're considered employees under the Fair Labor Standards Act, that ticks minimum wage laws, that ticks overtime compensation. All these sort of benefits and protections that are meant to protect workers would flow down to these athletes involved.
And to my three wonderful tables of students who are teaching sports law, the Johnson case is currently sitting on your syllabus for early December with the notation on there, subject to change if a new decision comes down. We all lucked out that we didn't have the new decision come out when we're speaking. It might come down before you actually get to read the case. Michael, you've been incredibly patient as we've talked about everything leading up to you. But you actually are on the ground floor here in many ways. And you're very directly involved in trying to lead to some college athletes at least being classified as employees. And unlike McDonald's case, unlike the Johnson case, it's not filing with a federal court. You're approaching this in a different way. So our wonderful diverse room, and the great thing here is you're not a lawyer, and pretty much few people in here are lawyers, so just speaking in layman's speak so we all get it. What are you working on, and what's happening?
Well, Mark, thank you. As you said, I'm not a lawyer. I wanted to make that clear at some point so that nobody gets any false impressions. But my wife is a lawyer, and my father-in-law is a judge, was a retired judge, and my brother-in-law is a lawyer, and they call me a paralawyer. So I've decided to embark in this after I left the board. I was on the board during 2015 and until 2021, which is the end of the Northwestern unionization attempt. So I knew that. I followed that very closely as a trustee at a sister school in the Big Ten. And after I left the board, I started getting involved in athletes' rights, and the new general counsel at the time of the NLRB, Jennifer Abruzzo, had put out a memo in September of 2021, September 29, 2021. If you haven't read it, I would encourage you to read it. She's very explicit in that she's building off of the regional director's case at Northwestern, which found that scholarship football players were in fact employees and they were allowed to vote for unionization. She extended that and basically said it doesn't matter if you have a scholarship, you're still an employee. And she didn't really seem to draw any lines there. So what I was thinking is, okay, is there a line or isn't there a line? She said some players of, I forgot what term she used, some athletic type students were employees, and I didn't know if she drew the line at the divisional level or by the sport or by how much money they brought in. A lot of people have tried to kind of figure that out. And I heard her actually say in a podcast soon after she put out the memo that she really didn't think that there was a line, that all students would possibly be considered employees regardless of what sport they played or the division or the type of school they were at. So that led me to the point just very quickly where I was trying to find an athlete, and I worked for 6 weeks contacting people I knew, athletes I knew, friends' kids, friends of friends' kids, and so on. And I could not get one athlete to agree to do anything related to the NLRB. And then I just happened to talk to an attorney who told me, well, I actually found a D3 football player at a small private school in Minnesota who was considering it. And after he told me he was considering it, I thought, oh, I better find out actually how to do this. And so I contacted some lawyers and also the NLRB office in Minneapolis and kind of got the lay of the land. And one of the attorneys I was referred to is actually the attorney who did the work on behalf of the Northwestern football players in 2014 and 2015. And I explained what I was going to do, and if any of you know lawyers, lawyers always want the best case. And they said, D3, no way. Don't even bother. Don't waste anybody's time filing a D3 case. I said, well, if I had a D1 case, I'd go forward with that, but I don't have that. He goes, by the way, you don't even need a student to file this. You could file it. I said, well, how is that? Because as I was a trustee at the University of Minnesota, we got sued all the time. And the first thing we would do is we would motion for summary judgment, and usually we would say that whoever was suing us didn't have standing. And I said, how do I have standing in this case? And he said, in order to file an NLRB charge, you don't need standing. And I said, okay, then why hasn't anyone done this before? Not had an athlete, and anybody in the entire country or the world could have filed what I filed, which was just a simple misclassification charge based on what Jennifer Abruzzo wrote in her memo, which was guidance to her field offices. And I thought, well, he said, pick any private school. And I said, well, if I just pick any private school, that could just be like a Northwestern situation all over again. So I just said, why don't I just choose the entire NCAA, 1,200 schools, I don't know how many hundreds are private, but that was what I thought was a good place to start. And then I felt that I could always amend the charge at some later date. I didn't want to overwhelm the NLRB system, knowing that they were underfunded and still are underfunded, even though they've received more funding. So anyway, that's kind of a brief example of what
Thank you. Now, I'd like to ask the next question to everybody on the panel. And Michael, I'm going to start with you, and why don't we move our way this way from here. Professor Duru did a really erudite job of going through the history of college sports, and he laid out the case one way. I mean, if you talk about the amount of money in college sports overall, you talk about the Ohio State University programs that bring in $252 million per year from the college sports program. You talk about the coaches and athletic directors who make 3, 5, 10, upwards of $10 million per year. You talk about a coach who was recently fired at Texas A&M University who'll be paid $77 million not to work. And it's incredibly compelling. Now, I could also tell the story of any of our sports teams here at Baruch College. There are no revenues that come in from attending most of these games. The athletic director that works at Baruch is paid comparably to the way faculty are paid. The coaches, many of them are volunteers. It paints a different picture. So I want to ask the very difficult question, and you get as into the weeds or out of the weeds as you feel comfortable. Are we suggesting that Division III track and field athletes are employees? And if not, how do we draw the line between those college athletes who we think reasonably are, or if you prefer, the normative should be treated as employees, and those who should be seen as enjoying the opportunity to participate in an extracurricular to give them personal growth? Michael, I'll start with you, but I'd like everyone on the panel to give this question a go.
Well, it's interesting. When I was in high school in the early 80s, I grew up in Ames, Iowa, where the home of Iowa State University is. Iowa State University had famously hired Johnny Orr as their basketball coach from the University of Michigan. Kind of an odd move, right? Well, the reason for that was because Iowa State actually was offering to pay their coach the most of any basketball coach in the country. And Johnny Orr, when he found out that one of his assistants was interviewing there and what the salary was, he decided he would go get that job himself, and he did that. Guess how much that salary was? It was $45,000. My father, a professor at Iowa State University, made more than that at that time. At the same time, I can't remember what school it was, but at that time, the highest paid football coach was already at $1 million in the early 80s. So we're talking about big money in college athletics. But if you go back to the Paul McDonald argument, he's one of the lawyers in the Johnson case. And the Johnson case has civil rights issues all over the place in their pleadings, in that they mention the 13th Amendment, which abolished slavery, And then there's the Van Skyke versus Peters, I think, Peters case, which is the slavery loophole exception, which is what the NCAA has been using in some of their defense pleadings. They basically are saying, hey, we know that there's an exception to the slavery prohibition in the 13th Amendment, which is, people who are incarcerated. And so the NCAA was basically making the case that if you're incarcerated, we don't have to pay you. And I know in some states, like where I come from, they make license plates and things like that, and they make like $1 an hour or something like that. But, but that's beside the point. The point is that there are a lot of issues related to this. But Paul McDonald is really making the case that if you're a work-study type student, meaning if you're in the student body and you're taking tickets at the game or selling hot dogs, et cetera, you are an employee of the university, and therefore you have all of the rights under the laws in the United States that, either state or federal, that cover employee status and what they need to do for you. In fact, you could see ticket takers unionize at some point. I mean, they've always had the ability at a private school to do it. No one has done it. But recently, you have undergraduate dining workers at Dartmouth College who are unionized now as of May of 2022. And so you can see the movement is kind of getting to the point where if you're not happy with your relationship and your terms and conditions with your employer, then you can organize and work collectively with your peers, your colleagues, to try and improve those terms and conditions. So I would say, whether or not there's a line to be drawn, that's the question I'm asking. I think the general counsel of the NLRB will see what happens in the Dartmouth case, which is the only petition for unionization since Northwestern is going on right now. In fact, they had their hearing with the NLRB in Boston last month, and I was actually expecting that we would know by now what the resolution of that particular hearing was, because I thought they said during the hearing that October 25th was going to be the deadline for the regional director to make a decision, similar to the Northwestern case. And so I don't expect the case to be really any different than what happened in Northwestern, but we'll see.
So, Michael, I can't get you to draw a line somewhere. Jeremy, if I could ask you, I'll just give a particular example. One of the students that I'm currently teaching this semester in sports law is a softball player at Baruch College. She also happens to be our SAC representative and an excellent student, which is neither here nor there. But let me ask you, Division III Baruch softball, are they employees? Where would you draw the line?
Yeah, so I'll answer the question. I have to say, Michael said something, I think, he referenced the Johnson case, the Paul McDonald case, okay? So the question is, and it is a question we're all trying to figure out, where do you draw the line? And I think the Johnson case is an interesting exploration because the Johnson case was brought by the same lawyer who brought a case before that failed, called the Berger case. So Paul McDonald brought a case on behalf of University of Pennsylvania track and field athletes, all right? Same Fair Labor Standards Act argument. And the court, it ended up being the Seventh Circuit, it was brought out in Indiana, and the Seventh Circuit said, no, you lose. But there was a concurrence, and the concurrence said, well, this isn't really compelling, these University of Pennsylvania track and field athletes. One, the University of Pennsylvania, there are no scholarships there, so non-scholarship. Two, track and field doesn't bring in revenue. We're just not compelled by this. But, if you are dealing with student athletes from a revenue-producing school, revenue-producing sport on scholarship, maybe we'd think of it differently. So literally, Mike talked about trying to find an athlete when he was doing the work he was doing to bring the NLRI claim. Paul McDonald went out and he found a football player, revenue producing, at Villanova on scholarship and brought the case. And that's the case that's progressed further and is before the Third Circuit. So the Seventh Circuit drew a line. and it said, okay, revenue producing on scholarship, we're going to view you as potentially employees, but otherwise, no. So the whole question is this line drawing. And those who oppose, many who oppose this push for employment status of student athletes make the argument that's in the back of, that in the background of Marc's comments, which is, well, it would wipe out the softball player at Baruch, who enjoys it and they're benefiting from it, because if they were made, employees, then Baruch would probably just drop the program because it wouldn't be worth it financially. And so I don't know where the line should be drawn, but I'll say this: if all student athletes are deemed to be employees, there are programs that currently exist, collegiate programs, most of the D3 programs, many D2 programs, maybe some D1 programs, that will be dropped. And that's going to be a consequence of, the determination. And some people feel that's a bad enough consequence that we shouldn't allow any student athletes to be viewed as employees. But others say, hey, I'm the starting quarterback at University of Alabama driving all this revenue. I deserve to be an employee, and I don't care if the Baruch softball player doesn't get to play sports anymore.
Thank you. John, now, we have a paper coming out in Illinois Law Review. It's one of the interesting pieces because the two of us wrote it together along with Michael McCann at University of New Hampshire Law School. And one of the things we thought about in this paper was this very issue of how do we draw a line? And we're hoping that it'll help the National Labor Relations Board as well as courts to figure out how do we draw that line between college athletes that are operating for the benefit of a university under their control and those that are not. And Michael McCann's not with us today. He's currently talking about the paper as we're here to the faculty athletic conference, to faculty advisors to the NCAA. He's discussing that in Indianapolis. We get to talk about that today here. So John, what conclusions did we come up with, and where do we think, or what do you think we should be drawing that line?
Yeah, so I think for me, and one of the things that we argue in the paper is if we look back to sort of what the courts have said, if you look back to, I think it was 1975, but there was a case against Western Michigan involving a football player with the last name Coleman, and he sued the school. He wanted access to workers' comp, and one of the reasons that the case was denied was they said that football wasn't an integral part of Western Michigan's business. And that might have been true in 1975, but when we start looking at the role that football plays at a place like the University of Alabama, or the University of Oklahoma, or the University of Texas, or the Ohio State University, pains me to put the D in front of it, but the Ohio State University. I mean, we're looking at a very different universe that college sports plays at certain places for those universities. And so I'm not sure that it's a bright line rule, but I think if you look at the role that sports plays at various universities, that's a good place to start. If sports are generating significant revenues to the university, you look at those sports and you begin to start ticking boxes. So football at major Power 5 schools, that is going to bring in significant revenue to the school. Oftentimes schools are redistributing that throughout the athletic department to support a number of non-revenue sports. Football is a pretty easy case. Men's basketball, pretty easy case at the top levels. Women's basketball at a number of schools is also likely going to fall into that. And then you will have sort of the unique exceptions. Hockey at the University of Minnesota, baseball at a few schools, even softball at a few schools, perhaps gymnastics at at Louisiana State University. So I think looking at the role that the athletic team plays within the business of the athletic department is a very important factor. And measuring that through not only the revenue that goes in, but how much of that is then being put out into coaching salaries. If you're paying Jimbo Fisher $77 million not to coach your football team, tell me that's not integral to your business. I mean, you think you can generate enough money that paying someone $77 million not to work will result in you making more money. So that's an incredible thing to think about. The other sort of factors to consider are what roles are those teams playing for the schools in promoting the school. When you see promotional literature from The Ohio State University, does it feature a football player? My guess is you can't get very deep into their marketing materials without seeing a picture of the horseshoe. Same sort of thing with regards to any of these major schools. Are they using athletics as the front porch of the university? Is this a marketing ploy where the greater university is selling the football program as a piece of the pie here? So I think, no, I don't think, unfortunately for the Baruch softball players, that under our argument, they'd qualify as employees. I do think to the extent that athletes are generating revenue for their schools, there's more likely a case. And to the extent that coaches are generating millions of dollars in salaries, that is further evidence in support that they are an integral piece of the business of that university.
Mark, can I
Please
can
do.
I jump
Please
in?
do.
I wanted to, we'd be remiss if there's one matter that none of us have talked about, and before we're done, I want to make sure we talk about it, and it goes directly to John's point, or touches on it, which is that the Dartmouth basketball players have filed for union status. And their lawyer's argument was, among other things, it doesn't matter if they're driving revenue. That's not a test that we need to consider. And that may come down even before the Johnson decision. So it could be coming down at any moment. So sports law students, this is a dynamic field. I mean, if you're looking at the news every day, you're going to see stuff relevant to your course. And so when the decision comes down, that may give us an eye into, where that line might be drawn, because Dartmouth is saying it shouldn't be drawn at revenue producing. We don't produce revenue really much here at Dartmouth, but we should be considered employees under the NLRA.
And I mean, Dartmouth basketball is such an interesting one. If we look at the cases we have going on, Dartmouth basketball looking to unionize, Villanova football, it seems like some of the ones we're looking at, if we go by the test that John spoke about that we co-authored, really is on the borderline. Now, Dartmouth is going to say they don't bring in revenue from the basketball program, but who'd Dartmouth open up their season with this year?
Yeah, Duke University.
And how much does it cost to go to a game at Cameron?
A fair bit. And it should be noted, to Mark's point, if you ever watch sports and you see early in seasons, football, basketball, where you see teams getting blown out by 30 or 40 in basketball, or by sometimes 30 or 40 in football, it's because small schools are playing huge schools, and they're getting money for playing that game. They're getting money to get beat up on.
Now, next question, I'd like to start with Professor Holden on this one, but I'd also like to get everybody's take. We all understand the NCAA is a trade association of these member colleges. We all understand that the colleges don't want their athletes to unionize. Now, that's not surprising. Most businesses, if they could control it, don't want their employees to unionize. And we understand that most colleges don't want their athletes to be treated as employees. They don't want to provide them for the benefits. Now, in trying to lobby Congress to pass a statute to prevent college athletes from being treated as employees, the NCAA has made a lot of arguments. And one particular argument they made, and not because someone makes an argument, doesn't mean that it's an earnest argument. You're always going to try to make the point that you can in the way that's most compelling to the people you're trying to make it to. And one of the points we see coming from the NCAA lobbyists is they claim if we recognize college athletes as employees, they make the argument that it's going to hurt women's athletes, and they make that point particularly. Now, I had invited Maddie Salamone to speak here today, who I would have loved to have had on the panel, because she's both involved in college athlete organization for employee purposes and has been deeply involved in women's college athlete rights in Title IX. Unfortunately, we were not able to bring her in here today, but I'd like to ask each of these panelists, is this an earnest concern, or is this a red herring?
So I think it's a red herring. I think many of the NCAA advocates, in their efforts to convince Congress to pass legislation in their favor, stopping either the declaration that athletes are employees or rolling back NIL, are a red herring. The reality of the matter is that neither the NLRA nor the Fair Labor Standards Act factor in the effect that this has on non-parties, right? We're asking the question of whether these athletes are employees. The question of how that impacts other groups is a matter that we need to deal with separately. And that you shouldn't deprive rights from one group just because that may have an effect on another group. So I think it's largely a red herring. I don't think that there is a lot of evidence out there that supports the idea that this will have some dramatic effect on women's sports. We have not seen a dramatic effect from NIL on women's sports. I think we're in a similar boat. I think where you do see some effect is potentially related to which sports the athletes would qualify as employees versus those that don't.
Jeremy, I'm going to ask you the same question, but if you'd like, to the extent you also want to talk about the intersectionality between race and gender, feel free to go there as well.
Sure. So, yeah, John's right in that the NCAA's argument in this regard is not a legal argument. And I don't know that it's an earnest argument. If there were a consequence for Title IX, there would be a problem, without question. And every university would have an obligation to structure things in a way that protected women's opportunities to participate. The reason I'm not sure that's an earnest argument from the NCAA is, John mentioned NIL. Does everyone know what NIL is? I don't think we've really talked about it in depth.
I'm very happy that my sports law students are all nodding yes.
Okay. I should ask one of them to stand up and explain it.
And my IP students. Maya, we're not going to ignore you in the far table there.
So basically, NIL, name, image, and likeness. Student athletes, before a couple of years ago, student athletes weren't able to leverage their name, image, and likeness for endorsements or sponsorships. If they did, they were made ineligible. There was a lot of litigation on it, but ultimately the California legislature said this is ridiculous. In California, you get to do it if you want. Then every other state, not every other state, most other states said, well, if we don't pass similar legislation, California's going to get all of the great recruits from our state, and they're not going to go to Alabama or Georgia or wherever. So then they passed their own. And so basically, across the board, you can leverage your name, image, and likeness. You can go and endorse Wheaties or Reebok or whatever. So before 2 years ago, when the NCAA was put into a box and had no choice as a consequence of what the California legislature did, the NCAA said that NIL rights for student athletes would destroy college athletics. They'd be over. There'd be nothing left. This is 2 years later now that we sit here, or going on 2 years later, and there's plenty left. And so I think that there's a similar argument here. The NCAA is making the argument that if we follow the course that we're discussing, women aren't going to have athletic opportunities in college. But if we follow the course that they were talking about, they will. It'll just be upon the member institutions, the universities, to make sure that it happens. So I would say it's a red herring. I've talked a lot already. Let me pass it to Michael. Maybe get them.
I see Michael's taking some notes, so I think we're going to get some big words here. Jeremy, thank you for passing the baton. Michael, it's all yours.
Thank you. For those of you keeping score, we are all in agreement here. It's a red herring. And I want to take you back to the pandemic. Do you remember the pandemic? It was just in 2020. What did the pandemic teach us regarding sports? Well, it taught us that we have essential workers, and those are the athletes. Without the athletes, the networks and all of the people paying the TV money don't write those checks. Okay, at the University of Minnesota, we were basically told by our athletic department that we would lose $70 million if we did not play football that year. Now, there's a whole other story about how that transpired into the Big Ten eventually playing 8 games and out of 12, and the University of Minnesota receiving $42 million instead of 0. But that's another story. I would say the other thing that we were taught during the pandemic is a lot of sports got cut, or a lot of athletic departments tried to cut their way out of their, because no one knew what was going to happen during the pandemic, right? No one knew if it was going to be 1 year, 2 years, 3 years, or in terms of sports budgets, how it would affect them. But a lot of sports got cut. There were a lot of lawsuits. Title IX is important. It's another federal law, but so is the FLSA and the NLRA, and there's all sorts of other laws that affect every private business or every business, for example. You can't just choose which laws you're going to follow in this country. At least you're not supposed to. Some people do. But I think the important thing that we need to discuss now is how is this going to play out? Is are non-revenue sports going to be affected? I would say, yeah, they probably will in some places, just like the pandemic did. But it will probably be the non-revenue men's sports. And then there's the whole Olympic side of Olympic argument, which is we rely on our colleges for Olympic development, which I think is a whole other subject, and there are ways to solve that problem as well.
Thank you, Michael. Final question for the panelists, and then I'd like to leave time to open it up for questions. I've tried my best to tee you guys up with questions that I perceive as leading the conversation in a particular way. But I'm sure in the questions I've asked, there's something I've missed. What have we not talked about today that each of you think we need to get into the conversation to make sure we're having a full and well-rounded discussion about college athlete unionization? What have we not touched on that you want to add to the discourse? I'll take these in any order you guys want to go.
All right. So one thing I want to mention, just sort of following up on the Title IX discussion, is that the majority of schools are not currently compliant with Title IX anyways. And if the NCAA wants to get serious about enforcing Title IX, now would be a great time to start. They're more than welcome to start ensuring that schools are being compliant with Title IX. It's not particularly a college athlete employee issue, but I think it's worth highlighting that the NCAA has a habit of running to Title IX as, well, we can't do this because of Title IX anytime that they're under threat, but don't seem to have an issue when USA Today publishes a report showing that 100 schools don't comply with Title IX on various levels.
I'll take the other two in whichever order. I see two faces thinking deeply, and I don't want to push anyone before they're ready.
There you go. Well, it's a tough question. There's so much that hasn't been covered. This is such, the topic is really, really deep, and I hope you all, if you're interested, do further research on your own about this. But I would my lane is the NLRB lane, so I'll stick to that, and I'll tell you more about that and the things I think that are important. One of the things we didn't talk about really is the joint employer theory, which was another component of the Abruzzo 21-08 memo. And that's what ties this all together, and that's why I decided to start with the NCAA, because the NCAA, being a private organization, is under the NLRA and the authority or the jurisdiction of the NLRB, and so are all the conferences. So the fact is there are a lot of private schools out there, and there are even more public schools out there, and that was the dilemma that the board had back in 2015. And I would just say watch this space about joint employer theory, because joint employer theory for the non-sports businesses, all the other businesses under the jurisdiction of the NLRB, joint employer theory is still a moving target. And if they decide that the way that I think they will, private schools and public schools and all of their trade associations and conferences like the NCAA and all the conferences are going to be under the jurisdiction of the NLRB. So just let's hope that's what happens.
Thank you. I'm really glad you brought up the joint employer theory. And again, for my sports law folks, we'll be getting there before the end of the semester. Jeremi, you've got the final word before you go to Q&A. What do you want to throw in that you would like to get a little bit more out on than what we've discussed?
All right, I'm going to go outside of the box on this one, Mark.
I like that. I like that.
I'm going to talk about something that, a dynamic that exacerbates the problem we're talking about, and that is eligibility to play pro sports in this country. So in order to get into the National Football League, you essentially have to be 3 years out of high school. National Basketball Association, essentially 1 year out. A lot of people don't know this. Women's National Basketball Association, 4 years out. And so the student athletes here who aren't getting paid, who we're talking about, they don't have an option to go and do what they're doing professionally in this country because of these rules put into place by those leagues. And so what that does is, it exponentially thickens the plot, in my view, when it comes to what we're going to do with respect to paying student athletes.
And Jeremi, just for the benefit of my sports law students, these age requirements that you're calling league rules, are they collectively bargained?
Yeah, so these rules are collectively bargained. They're collectively bargained between we talked about unions. Everybody's got a union. We haven't talked about pro sports. All the pro sports leagues, all the athletes in the pro sports leagues have unions. So if we're talking about the NFL negotiates collectively with the NFLPA, the National Football League Players Association. And together they come up with these rules. And it's interesting, since you raise it, it's in the best interest, generally, of those in the union to restrict entry into the league, because that gives them a longer career. If they can ensure that, it's a few more years before these incredible freshmen in college get to come out and play, then they may have another year or two under their belt making their money. So there are all sorts of dynamics that conspire, perhaps not intentionally, but ultimately against the student athletes we're talking about.
The last question I asked, I think, was definitely the best question I asked all day. We brought up 3 great points that I probably would not have gotten to. And to Professor Duru's point, we know in 2003, 2004, NFL player Maurice Claret brought a lawsuit against the NFL teams, arguing that they colluded to keep him out of the league with the requirement of a 3-year after high school education. One thing that probably very few people in the room know is that there was an amicus brief filed in the Southern District of New York and again the Second Circuit in favor of the NFL's age requirement, saying it was a good thing. And the authors of that amicus brief, the NCAA. So on that note, let me open up for the rest of our session, question and answer. I'd love to get some people to ask some questions. And here comes Seth Lipner, professor at Baruch College since 1981. Did I get that right?
82.
82. I gave you an extra year of
Much
seniority.
younger than I look.
Right up to the microphone, you've got the first question. First up, first go.
Okay, so following up on your excellent last question, which is what haven't we considered? The economics. What happens, the equity arguments you guys make are very powerful. But what happens to me, the fan, if the schools union, the athletes unionize? Do my ticket prices go up? Does my TV subscription to NCAA basketball go up? And as a professor, are the unions going to start coming to me and saying, how come you gave this kid a C minus? He deserves a B plus. Am I going to be, as a professor, subject to collective bargaining with respect to the educational mission of the college? And thank you guys, by the way, thank you guys very much for coming to our college and participating in this. It was a fantastic program. Thank you.
Thank you, Professor Lipner. I'm tempted to speak, and I'm restraining myself. So let me ask the panelists if you guys want to jump in.
I'll jump in. Well, on the question about grades, I don't know about this school, but C's get degrees, right? Okay. So, in all seriousness, so I don't think they're going to argue about grades as long as they're getting C's. But I would say that the economic part of this is, that's the big question everyone's trying to figure out. Everyone's got an opinion. Economists have two hands, right? On one hand and on the other hand. And so we don't know how that's going to work out. I'm a non-lawyer, but I believe that we need to follow the laws in this country. The misclassification issue that I'm trying to solve with the NLRB is a 70-year-old issue. And we didn't cover the history of that, but it goes back 70 years to the 1950s, where in order to avoid legal liability, the NCAA created the term student athlete to make courts, judges, and the public think that, and the athletes think that they were not employees and therefore were not entitled to workman's comp and other benefits. That was 70 years ago. And I think that it's gone on way too long, and it's about time that we solve that. But the economics, they're going to be what they're going to be. It's a free market. We live in a free market system. If your cable package goes up because of sports, then, that's the way it is. But hopefully you'll still watch sports.
Do other of you guys want to jump in?
Yeah, I'm going to jump in quickly to say it may be worse. It may be that it's not just that your subscription goes up. It may be that your university's team goes away, and so you don't get to watch them at all. But to Michael's point, you got to follow. The law exists, and if the consequence for those of us who like college football are that we don't get college football, then that's the consequence. I mean, Mike McCann, who's a friend of many of ours and co-authors with John and Mark, he argues that it's possible that we may see in college football basically the Big Ten and the SEC, like the AFC and NFC in the NFL, the two big conferences. A bunch of schools won't have football programs. The NCAA will be totally different in 5, 10, 15 years. If I'm a fan who doesn't get to watch my team play anymore, it's a bummer, but, the law is the law.
John, do you want to speak?
I think both these guys have summed that up pretty well. I think just because we don't like something doesn't mean that the law doesn't apply to it. And just because there are negative consequences and it's going to be potentially more expensive, it doesn't mean that we shouldn't do what's right.
I'm going to be a bad moderator and add a few points. And Professor Lipner, I'm sure when I'm done, I'll be pulled out of the law department and put in the economics department. Back in the 1970s, when the baseball players first started unionizing and pushing for free agency, the argument was made that increasing the salaries of players was going to increase ticket costs. And over a prolonged period of time, economists did a series of studies because you would see that players' salaries were going up. You would also see that ticket costs were going up. Now, as anyone that takes statistics knows, and I'm going to sound like a statistics or economics professor for half a moment here, correlation is not equal to causation. And all because two things are going in the same direction doesn't mean that the one we think is causing the other, in fact, is. And what all of the studies actually showed was it was not the increase in pay to baseball players that was leading to the increased ticket price, but actually the other way around. That baseball teams were profit maximizers that would always charge the most money that they could for their tickets, and as the amount of revenue increased, the players were able to bargain for more money. Now, I'm going to take a leap of faith here that I don't have evidence of. And I'm going to presume that colleges, when they charge their price for tickets and other things, are already profit maximizers. If that is indeed correct, what that leads me to believe is that having to share revenues with college athletes will not increase the price of tickets, because if they increase it further as a profit maximizer, all that would do would be decrease ticket sales and lead to less revenue. So if what they're doing is the economically optimal outcome, there will be no way to raise prices beyond what they have. What it will lead to is not the increased cost of going to games, but instead shifting of revenues, shifting of expenses. And if some of the expenses now are being used to pay college athletes, there might be another group that could get less of the pie because the remaining amount of income goes in. So my hunch, and it's a hunch, it's a hypothesis, it's not an answer, is your ticket prices won't cost more, but some of your coaches might be making less. Maybe someone who's a statistics major will like to test this one over the next several years. Okay. Who else has a question? And I encourage students as well. The microphones are not only open to those of us who are on faculty and visiting. Anybody is more than welcome to ask questions. Who was, I think you were next in the queue, and I will get you right after that, Bob. Go right ahead.
Thank you. In regards to college athletes, and are they insured in health insurance, disability insurance, and in event of injury or death? Is it the college athlete responsibility to provide themselves the insurance, or the colleges will provide it? And if they become employees, then with disability insurance, if they become injured, they will be able to make a claim.
So many college athletes, particularly those under the age of 26, remain covered by their parents as their primary insurer. Schools will pick up for athletes who do not have coverage under their parents' insurance and maintain catastrophic injury insurance. Schools will also periodically provide loss of value insurance for certain athletes who are expected to be high round draft picks in NBA or NFL drafts. But certainly if they are employees, they would have access to state workers' compensation boards as any other employee in a state would if that were to happen.
There have been times when colleges who have meant to insure players have failed to do so. The most notable one in the media eye involves the star college quarterback at the University of Colorado, Shedeur Sanders, who apparently the University of Colorado, while maximizing revenues selling beer and having expensive ticket sales, forgot to insure their star quarterback. Luckily, he was not seriously injured. Well,
A handful of very quick comments, questions. First, I think Mark has been unduly modest that Baruch actually has a very famous alum who apparently played for the men's volleyball team, George Santos. And then in terms of the benefits of student athletes, is it so that at some schools, students who are not otherwise academically qualified may get admission? That would be a benefit we haven't spoken about. Is it possible that the student athletes who have these high-paid coaches, perhaps they're paid even more than our panelists, that they're getting a wonderful education for the same tuition? If there are in fact employees, if student athletes are employees, are there taxable income implications? And lastly, are there possible university tort liability implications for the torts of their employees, their student athlete employees?
that's a lot, Bob. Thank you very much. As the George Santos unendowed chair of sports law, I will cede to anyone on the panel that wants to answer any one of these pieces of the questions that Bob Weiner had posed.
Well, as I said before, we should follow all laws. That includes paying your taxes. Students at a very young age, I don't know, the students are right over here. Let's just see a show of hands. At what age did you realize that there's a thing called the IRS and that you have to pay your taxes?
You're looking right at Jada, who made a point in class last week about how she feels about taxes.
Well, nobody.
And that was not plotted.
But I would argue because the whole theme about paying taxes or not paying taxes is translated into, our TV media and, all sorts of storylines involving tax evasion and such. Everyone knows that if they make money, they have to pay taxes. Whether it's a high percentage or low percentage depends on where you live and all that kind of stuff. But I would think that most people realize it. Whether or not they realize, you have to file on or about April 15th, the details of that are not important. But I think that the NCAA is using that as kind of, oh, well, kids are going to have to pay taxes. It's like, yeah, well, that's what happens when you make money. That's just all there is to it.
I'm sorry if I wasn't clear. The question is whether the scholarships would then be.
Bob, I have a article on Boston College Law Review in 2017. It's about a 55-page article. I'll send it to you after, and you could have a long read to a short question.
But let me just answer that question in a different way. So a lot of colleges have tuition reimbursement programs, and employees who also want to get another degree or get their first degree have an opportunity to participate in those programs. I do not believe those programs are taxable, at least not in Minnesota. So unless you're going to change that for everybody, it's not going to change for students either who are athletes.
Well, we have one and now possibly two student questions, unless it's a joint question. Jada, you've got the microphone.
I actually have two questions. One is they're both related to NIL, but one is more in a misogyny-based area, whereas the other one is more in a wealth gap area. So I don't know if which one you guys want to talk about first. But you guys had brought up Shedeur Sanders, and I had talked about this earlier in the semester with Professor during our little gap before sports law, and I had asked about the perspective that people have that some players within the new era of NIL are gonna get significantly better money values rather than other players. So they show the standings of the highest paid athletes, and the majority of them, the first one I think is Bronny James. His father is LeBron James. Shedeur Sanders, his father is Deion Sanders. Arch Manning. I don't know if Libby Dunn comes from a high-profile family, but I'm pretty sure she didn't grow up broke. So my question on that is, do you think that a lot of people are going to disagree with NIL based on the fact that the majority of the athletes that are getting the highest salaries do come from wealthy backgrounds compared to others?
Could we take this question, because it's a great question, and Jada, we'll let you get your second question in after everyone has a chance to answer this one?
I think it's a fantastic question, Jada. It's a very astute question. It's a fantastic question. I think what's already happening, what's going to happen, and let's all keep in mind, these are the early days. The NCAA removed its prohibition on this sort of stuff in July 2021. So I think we're a year and a half in. And so it's not surprising that the early actors are those with family connections and knowledge of the industry. But I think what's going to happen, it's already started happening, is more and more people, many of whom are lawyers, but other advisors of different sorts, getting into finding their own profit motive, recognizing they can get a certain percentage of the deal, and reaching out to and seeking to empower those who might not have parents who played in big leagues and may not have a lot of money, to make sure that those individuals also get NIL opportunities. The problem, of course, is that often when you have people who are profit maximizers who are coming into an industry like this, particularly when it's not terribly regulated, which is one of our problems, is that those individuals are likely more susceptible to being fleeced is too strong a word, but being taken advantage of and paying high commissions and and so on and so forth. So there are a lot of problems born of what you're describing, but I think more and more student athletes are going to get the opportunity for NIL as more and more individuals who want to make their own money off of it, who have no athletic involvement or talent, get into the industry.
If I could add 30 seconds of color to Professor Duru's point before you get to your second question. As we talked about last class in sports law, we talked about agent regulations of lack thereof. And one of the real problems in this country is most of our state, as well as our federal sports agent regulations, were not passed to protect the athletes. They were passed to protect the interests of the colleges that were in the NCAA. So I agree entirely that there are some college athletes that are certainly being fleeced by agents. And again, to steal a term from my colleague Sharif Musa, and I love the way he uses it, he says if we don't have greater laws, most people will fall to the moral minimum. They'll do just what the law requires. And I think one of the ways to help resolve these problems is we need new, stronger sports agent law, and frankly, law where the agent's obligation is to the athlete and not to the NCAA. You had one more question, Jada, jump in.
Yeah, so you guys talked about red herrings and related it back with how, like, if we should give NIL to students, but although, like, women athletes will get, like, there'll be a big significant pay gap, I guess you could say. So I remember, I don't know if it was a year or two ago, but the Stanford women's basketball coach, she had said some comments. I'm not a Libby Dunn's fan, guys, but she's just like the best person I could think of. And she had talked about the fact that she didn't enjoy NIL based on the fact that a lot of girls are going to, in her opinion, over-sexualize their bodies. Do you think that misogyny, in a sense, will have, like, I don't want to, because I understand what you guys are saying about, like, the red herring and that we shouldn't not focus on the larger issue, and I get that part, but in the sense of, like, going back to what the Stanford coach said, I think that, you know, no one has a problem when men go on GQ shirtless and they get, like, whatever type of commission they get on that magazine cover, but do you think there's going to be a problem when girls are trying to also get the same pay, but they'll have to go on, like, Sports Illustrated?
I think that's a wonderful question. I mean, I think even more broadly, the name, image, and likeness itself, if we look at this world and Instagram and TikTok and influencers, I think it's very fair that you raise that. Do any of our panelists want to jump in? I think it's a great question.
I think it is a great question, and it's a question that we've wrestled with for a long time in sports. If you look back 20, maybe even 25 years ago, Anna Kournikova, tennis player, biggest female marketed tennis player, she never won a tournament. And so there was a lot of frustration amongst the other female tennis players on tour because she was receiving a large number of endorsements despite not having the success of some of the other players. So I think this is a concern. And going on what Jeremy said, I think this is one of these things that this will be a factor, but I do think it's sorting out. Because if you look at some of the numbers, you're starting to see some of the more high-profile female athletes rise up the rankings. Not that I think that the rankings are particularly accurate, but Caitlin Clark, the LSU women's basketball players, yes,
Paige Buchers.
All these women are really rising up against these athletes who, going back to your previous question, do have that tremendous familial advantage of having parents who, I mean, Deion Sanders is perhaps knew sports marketing before sports marketing had a name. And I mean, he was marketing himself back in the 80s. So that advantage is certainly there, but I do think that the market is starting to correct some of these things. I think hopefully things will continue to trend that way.
Rocky, do we have time for one final question? I see somebody stand. Why don't you take our final question of the day? It's great to see another student up and wanting to ask.
Hello, my name is Mandeep, and I'm a third-year student, operation management major. And my question, and I know since the umbrella topic of like this panel is if college athletes should be considered as employees, and I want to ask, should a Division III player, let's say a basketball player on a team, should their level of pay, if they get paid as employees, should it be based on their level of play? Like, should a starter who's scoring like 20 points a game in basketball be paid less than like a role player who's scoring like maybe like 1 point a game?
You know, I think the same question, if you ask every faculty member here what the union should be negotiating for, same or different, we'll all have an opinion on that. And I mean, that's a very real issue in unions in general. Does everybody get the same, or do people get different based upon what they do? It's a fascinating question.
I'll just add to that. Well, the Johnson case is basically a minimum wage and overtime case. So if that's kind of the world that we end up living in, then players will make at least minimum wage if they're considered employees. But I think that, as we've talked about the free market and the previous question, the market's going to decide, the value of everybody that's in the market, whether they're athletes or non-athletes. So I think that's really what we could all keep our eye on. But, right now, anybody who's worried about how much money athletes are going to make in the future, I mean, it's a concern, but it's not a huge concern of mine, at least.
Yeah, I think Michael said everything on it. The key point is that there is a minimum wage, so nobody would get below that, but I think otherwise the market sorts it out.
I just wanted to finish off here by thanking once again all of the panelists. One of the things I love about Baruch College is we have a great, diverse student body who's passionate about a wide range of topics, and we try to do our best teaching our students, but we're not always able to expose them to a wide range of voices from the outside world. So the three of you guys did an incredible service today by allowing me to expose our students and allowing Baruch to expose our students to leaders in the field with different viewpoints. So thank you so much for taking times out of your day and schedule for being here today. And for those of us as panelists have different time commitments and different flights to catch, but at least I will stick around for a few, and feel free to try to reach out to anybody here before they have to run for their flights. And thank you for coming today.